Here's a common mistake that I see with Indian families in Texas is that they have an estate plan in place in the US in Texas, but they don't have an estate plan for their assets in India, especially when it comes to real estate for land, flats, commercial property, and so on. They don't have a real estate in place. Now, at least in my experience, the problem is that kids who have grown up in the US, they were born there, they were raised there, and they don't fully understand the way India works. I mean, it's one thing to come here on a trip and meet family and meet friends, but it is a whole another thing to work with government officials or to work with the courts just to get just to get the assets transferred from your name to your kids' name. That could be a lot of running around. So it is always advisable that you have a registered will in place, and that basically what that will do for you is that that will help transfer the assets that are in your name to your children's name. And if your children someday want to sell the property, any buyer or the sub registrar who is who's the authority to transfer title in India, they are more likely to accept a registered will. And a registered will is generally considered to be a safe and genuine document. So my advice to all Indian families in Texas would be, while you have an estate plan in place in Texas, also don't neglect making an estate plan in India, because that will help protect your kids, and also help them get the assets that you have acquired in India. Follow for more estate planning tips for Indian American families.